Yeah, it's Monday. I should be talking by now, but I'd just as soon sit here and listen to the theme music and wonder, am I ever going to escape from Washington, D.C.? My bags are packed. I'm ready to go. I'm leaving. I want to leave. I was set to go home Friday, but the jury did not return a verdict. And so I was thinking, oh, I'll let co-counsel babysit the jury, and I can always be available by phone. But somehow I just couldn't walk away from the fight, and I want to see it to the conclusion. So I remained in Washington. I re-upped my Airbnb for yet another week, and we will begin day 4 of deliberations this morning at 9 o'clock. Will we get a verdict today? I don't know. Will we get a verdict this week? I don't know. Will we get a verdict at all? I don't know. Well, I'm quite serious about that. If there are certain wrinkles in the law, in order to get a verdict, the jury has to be unanimous, at least in federal court, and then most state courts around the country. And it raises interesting questions. So consider in a criminal case, it's the government that has the burden of proof. In other words, it has to prove each and every element of the crimes it charged beyond a reasonable doubt to the unanimous satisfaction of the jury in order to get a conviction. The defense, jurors are told, need not prove anything. They needn't put any witnesses on at all. Well, here's a query, and this is one of these conundrums that the law doesn't even really acknowledge. If the government fails to persuade a jury unanimously, it fails to meet its burden of proof. In that case, the government or the defense should win, right? Because the government failed to meet its burden of proof. Wrong. Unless there's a unanimous verdict of not guilty, the case might mistry. And so there are legal doctrines that have evolved to cover what happens in a mistrial. And how do you square double jeopardy with that? And so a mistrial means the trial didn't come to the prohibition against trying someone twice for the same crime. Because it's a mistrial and no verdict, the government can try again. And so there's a doctrine called manifest necessity. And manifest necessity says that a court, in the absence of a unanimous jury, it's obviously necessary that the court needs to declare a mistrial because there's no verdict. Well, really? There's extrinsic and intrinsic manifest necessity. So you've got 12 jurors, all your alternates, were abducted, and one of them falls ill. You don't have a unanimous verdict. That extrinsic factor could affect things, and there could be a mistrial. We have alternates in the wings in this case, but I give you that as an example. Okay, I can see that might require a mistrial if the parties don't consent to have fewer than the statutory number of jurors, in this case, 12. But then there's also intrinsic manifest necessity. And in that case, both parties have fully and fairly been heard. But because the jurors can't agree, the court declares manifest necessity. And although there's been a full and fair trial process, the failure to reach a unanimous verdict results in a mistrial. Usually in a criminal case, once jurors report they can't agree, judges can give what are called Allen charges, encouraging the group to rethink their position individually in light of one another's expectations and experience in the hard work of the trial, and they go out and are asked to resume deliberations. If the defense, and that'll happen once, maybe twice. If that happens a few times and the judge throws in the towel, he'll turn to the defendant and say, "What's your position?" And the defendant will say, "I move for a mistrial." That move is a waiver. And so one of the things we're contemplating here in DC, should the point come, is do we not waive? Do we say, no, we want a verdict? And if the jury can't return a verdict unanimously, we say, well, we can't be retried either, because double jeopardy says you can't be tried twice. There was no manifestness. There was no waiver on an intrinsic manifest necessity claim, and therefore you can't try it again. The Supreme Court will not be recipient to that claim. Receptive, I should say, to that claim. And I've tried to raise it in state courts in a variety of ways.
Of course you have.
What can I tell you? It's the world, from a criminal defense lawyer's perspective, the world is one vast canvas of chaos, and you're not asked, you're required to paint on it in primary colors. So we'll see what happens. It's still early. There were hundreds of exhibits, 4.5 months of trial. It obviously is going to take the jury some time to reach a decision. And if it doesn't and can't, then I guess we might have to try it again.
Well, hello to all of the new viewers via Twitter. We can credit Mr. Ron Coleman with giving us a boost this morning. Thank you, Ron, if you're watching, and welcome to all of you who are new. We've got people watching via Rumble. Pete Atkinson, Lawyer Will, BTL, it's me again. They're all in the chat this morning. Pete's actually joining us from Rome, Italy this morning, and we've been joking with him, Norm, while you were giving your opening remarks there, that this seems to be a better time zone for Pete rather than being in Chicago. Perhaps Rome is a better fit for him for joining us on time. What do you think?
Well, I suspect that's true. I mean, knowing Pete's ability to consume wine, I suspect that getting up any time before 10 a.m. Eastern Standard Time might be a challenge for him, even though he's got more energy. Even though he's got more energy than the Vatican, and what's he doing in Rome?
I don't know.
Consultations
I'm
with the Pope.
Bit. Yeah, he said he's going to have to move out there. I'm probing a little bit. I asked if he was heading to the Vatican, but he moves in. He's a real G, so he moves in silence like lasagna, as the great orator once said. It's me again. Says welcome to all the Culminators. Indeed, we know that Ron Coleman has his own show called Coleman Nation, and those that culminate with him are Culminators. So yeah, again, thank you. Welcome. Let's work into some sports here real quick.
Oh, I don't want to talk about sports. I don't want to talk about sports. I want to get in my car and drive away. I want to get in my car because the Boston Bruins blew it. They lost to the Florida Panthers. Boston Bruins. There are 82 games in an NHL season. The Bruins won 65 of them. You get 2 points for a win, 1 for a tie. They had 133 points at the end of the season, more than any NHL team. So what do? They lace on their skates and they're going to play the Florida Panthers. I mean, how hard is it to beat a Florida hockey team? You turn off the air conditioner, during one of the breaks between the periods and the ice starts to melt. You got it, right? I mean, the Florida Panthers beat them in overtime.
Wait, they even use ice in Florida? I thought they just did the whole like rollerblading thing down there.
Oh, what's so cool is right outside the White House here, in front of Lafayette Park, there's a rollerblade hockey game perpetually going on in a restricted service. I've watched them with envy and thought, man, if I could trust myself on a pair of rollerblades, I'd ask to play. But anyhow, it's a tough time in Bruin Nation.
On a pair of rollerblades. We're going to keep you right where we got you for now, okay?
No broken limbs here. Ouch, at least I don't think. So I'm in mourning for the Boston Bruins. I want to get in my car, drive to the back bay, and really just whine a lot. I don't know what to say. Florida Panthers, we've got ice hockey in Florida. I guess we're going to have nude bathing in Boston, in December. I don't know.
Yeah, I think that's right. That's the way that things are going. The other thing that I personally wanted to follow up on from Friday, and credit goes to Mr. Luttrell, or I'm Miss Luttrell. I don't know which one it is, but I'm
it's the non-cis Luttrell. Just bang boom, Luttrell.
There are only
Luttrell, gender. Identify yourself.
We're talking about Massachusetts already, and we're going to get to that in a few minutes. But Luttrell, thank you. This came from our locals page. So on Friday, Norm and I were talking a little bit about the NFL draft. In particular, my Carolina Panthers had the first overall pick and took Bryce Young from Alabama. The number 2 pick, CJ Stroud, was from Ohio State. And I think I was giving some grief to CJ Stroud in particular because of what's known as the S2 test, or some results that had been apparently leaked to the media, and compared Bryce Young's 98 score to CJ Stroud's, I think, 18. We went back because Luttrell put a video into our locals page, and it was of the Pat McAfee show. And they actually had one of the founders, Norm, of the S2 test on the Pat McAfee show there to discuss what exactly the S2 cognitive test is and
what it
does. And it is a series of 9 indicators. So the co-founder that was speaking played college athletics, was athletics his entire life, and then had a catastrophic injury of sorts. And as part of his new depression, figured that he wanted to delay onset of real world and adulthood as long as he could. So he went for a PhD. And that PhD...
I thought you were going to say a law degree in criminal defense. I've made a lifetime out of juvenilia.
Yeah, some of us are crazier than this guy. So he, through the course of his PhD, and it was, I think, in cognitive psychology, is what he earned his PhD in, some version of that. Long story short, he and I believe a partner or two began doing all of the research related to what makes certain athletes fit for certain positions in certain sports. Voila, they come with the S2 test. And what it ultimately does is it provides teams 9 individual indicators unique to one specific prospect. And they got their start.
9 indicators of what?
Various different testing types. So
yeah, but like what? What kind
for
of stuff am I
football, it
going to
could
learn?
be, it could be decision making. So multivariable decision making as you are under physical stress, pushing out of the pocket, having to go through reads, and then also determine, what decision to make at a given time based on the down distance and time on the clock. But they have 9 various indicators, and he's somewhat opaque with the way that he talks about it because clearly there is some secret sauce there, a trade secret there for them to guard against, and they're still growing.
It's the Kentucky Fried Chicken of quarterbacks. Is that what you're telling me?
Well, for every prospect, so it doesn't have to just be quarterbacks, but I use quarterbacks as something easy, and this, for non-sports fans, it's what they really, look at as probably the most prominent position.
I want him to give me an S2 test because I think that
I want to do one as
trial
well.
lawyers.
So here's
the
why.
same thing as being a professional.
Here's what I find fascinating about this. They got their start because the Dallas Cowboys and New Orleans Saints wanted to evaluate all like 850 prospects coming in for 1 year, all 850 rookie prospects coming in 1 year. So this was before it had been ratified at a league level. This was the Dallas Cowboys and the Saints, who are not in the same division, but in the same conference, or not. Reverse that. Anyway, they're both in the NFC, not in the same division. Anyway, so they paid to have these results published unique to them on all 850 of these prospects. Fast forward, the S2 now has an exclusive agreement with every one team in every division of the NFL. And fast forward even further, now the S2 test is available to 2 teams in each division in the NFL. And so this cognitive test is a new set of indicators for the military, for sports organizations, for law enforcement organizations. So, Norm, I think that we may need to do the S2 test.
I think I knew. Yeah. I mean, in terms of indecision and inability to make up my mind about my major life goals, I think I would get a score of about 1 or no, because I just always thinking, geez, it'd be more fun to do this, that, or the other, that, or the other thing. And then I go to court and I have a good time and I'm like, okay, so, well, let's take the S2 test. I'm ready to go. Thanks for the update. Hey, what's up with Judge Lewis Kaplan? I mean, I knew we were going to get in federal court in Manhattan. I knew we were going to get a gag order case to Donald Trump. I didn't think it would be in the Jean Carroll rape case. As you know, Ms. Carroll is accusing Trump of raping her some 25, 26 years ago. She's kept it pent up all these days. Me Too set her free. And she's, of course, doing this for women everywhere. And so now he's being defended in this civil trial by Joe Tacopino. Ms. Carroll was on the stand last week, and Trump, through his counsel, Mr. Tacopino, has been admonished by the judge to watch what he has to say. And so Trump has been somewhat reticent about the trial, but Don Jr., or Eric, his second eldest son, took to Twitter the other day to talk about a legal battle allegedly being funded by political activist Reid Hoffman, co-founder of LinkedIn. It's out of pure hatred, spite, or fear of a formidable candidate. It's an embarrassment to our country. It should be illegal and tells you everything you need to know about the case at hand. Thus writes the president's son. Well, Judge Kaplan had something to say about it. He brought it up and said, look, I'm not amused by this. I said something this morning, the judge said, about your client now sailing in harm's way, conceivably with his son, if what I just heard is true. If I were in your shoes, the judge says, I'd be having a conversation with your client. There are some relevant United States statutes here, and somebody on your side ought to be thinking about them. Really, Judge? How about a relevant section of the United States Constitution called the First Amendment? How about some relevant Supreme Court case law against gag orders? Now, mind you, I think Eric, Eric's only gift in life is being born to a wealthy father. If he had to live by his wits, he'd probably starve. He'd probably starve, but he's got a right to speak. And I don't think the court has jurisdiction to impose a gag order over a non-party in the case. And so I think Eric can say whatever he likes within the confines of the First Amendment, and he can comment on the judge's attempt to silence him as well. Now, Eric apparently buckled and took the tweet down, but this raises a very, very serious issue. Um, Lawyers have an obligation not to speak out, especially during trial, and it arises from rule of professional conduct against prejudicial extrajudicial trial publicity. You're not supposed to comment on witnesses. It's a rule that frankly makes no sense, and it demonstrates that no one really believes the law is effective. And what do I mean by that? Jurors are presumed to follow the law. And all jurors are told to ignore media content, comment about a case. And if they become aware of media content about the case, to bring it to the court's attention and not to discuss it among themselves. It is a standard jury instruction in every jurisdiction that I am aware of. So when you try to bring up, during the Proud Boys case, for example, was outraged by some of the publicity incident to the January 6th House report during the trial.
And we talked a lot about that. We did.
Yeah. The response was the jury's presumed to follow my instructions. They're not going to be reading this. Okay, then who cares what a trial participant says? Who cares what a lawyer says? If the jury's not reading the press, then there can be no press that adversely affects the trial.
That's absolutely right. Here's the easiest anecdote we can use to compare, because I think this is last week when President Biden announces his reelection. And then what did he use visually and anecdotally as his draw for his campaign is everything related to J6, all of the smoky kind of,
as my jury was going out.
Right. Exactly. As the jury is going to deliberate in a Proud Boys J6 case. So I think you're right over the money here, Norm. It's irritating to me that it's, one rule for thee, but not for me.
Well, so we've got this rule of professional conduct. It's last been tested in a fulsome manner in a case called Gentile versus Nevada Bar Association. And that was a complex case that is not directly on point here, but there is existing law out there. The court also asserts its power typically over trial participants, that is, parties. Thus, in the Alex Jones case, Judge Barbara Bellis, no friend to the First Amendment, asserted that Jones should be sanctioned for some comments he made about opposing counsel. And she sanctioned him in the form of refusing to hear a motion to dismiss that might have ended the case early. We took that up to the Connecticut Supreme Court, and they held that the trial court had inherent supervisory authority over trial participants. Well, we tried to get the United States Supreme Court to hear that, and they didn't. And so that stands as the law in Connecticut, and it stands as the law in most jurisdictions. But if you are the son of a trial participant and you're not a lawyer, this court has no jurisdiction over this young man. And to suggest that there are statutes that he should be aware of, is this a claim? What is the statute, Judge? This isn't a claim of jury tampering. It's not a claim of corruptly attempting to influence an official proceeding. What is the statute? And so, I'm disappointed that Eric backed down. I think Eric should have stood his ground and said, you got a claim, bring it. Let's see what you got. And he should have taken this case. He should have drawn a hard line in the sand and said, cross it and let's see where we go. Because I think he is within his rights to speak.
I don't know.
Candidly, I want to know more. What are his reasons for thinking this case is being funded by Reid Hoffman?
I think that the age of the allegations, they're more than 25 years old, and there's no recollection on the part of the plaintiff as to what season it was, even what year it may have been that this occurred. She says that she confided in certain people, but I think the overarching theme of the criticism of this case is that it appears, and to be clear, this is a case that you and I have not discussed whatsoever on this stream or podcast. We've talked about the four cases attendant to Trump. This civil lawsuit for allegations of rape, that's not one of those four. And I think for that reason, Norm, it is perhaps the position of Trump and his advisors that Eric not create smoke where there's no fire, for purposes of focusing effort and resources on battling the forthcoming gag orders and issues that we're likely to see in these other four cases that are being drawn up, right? The one in particular that you were talking about last week was the potential indictment in connection with the events of January 6, 2021 behind Vice President Trump's testimony before the grand jury.
Pence, Vice President. Yeah.
Sorry.
No, I hear you, but I mean, Trump suffers from no lack of lawyers. I read this morning that he had six lawyers associated with him, and some of his co-defendants attended a civil deposition of Michael Cohen in the case brought by Letitia James in the Attorney General's office in Manhattan. I think the First Amendment matters. I'm disappointed in Eric, and I'm disappointed in the Donald.
We've got Lawyer Will's adding some insight here for us, and I'll say that LinkedIn is a pretty insufferable place. I don't know how much time you spend on there, Norm, but I think that's where I was sending. That's our origin story has some roots in LinkedIn. But Lawyer Will says that the New York Times reported Reid Hoffman is helping to fund the case. Reid Hoffman is the founder of LinkedIn and a big Democrat donor. It's like how Peter Thiel funded the Hulk Hogan case against Gawker. T-Girl adds, according to Bloomberg, Hoffman admitted he is funding the case. And this to me sort of begets a question of what words am I searching for here? But election financing.
No, absolutely. And what's more, how in the world does the judge think that it's not appropriate to question Ms. Carroll about the funding of the case? This reminds me back in the Sandy Hook case days, we were never able to get evidence from the plaintiffs about who was funding that litigation, and the trial judge backed him up. I mean, motive for bringing litigation is never collateral. And it seems to me that this is something that should be brought out in this case. Having said all that, I suspect Trump will likely lose the Jean Carroll case. And here's why. Remember that old Access Hollywood claim that he made? You can grab him by the short hairs, by the pussy, as he put it. And, they don't say anything. And when that remark sounds eerily similar to what Ms. Carroll is alleging happened in Bloomingdale's or wherever it was, where she had her encounter with the Donald. Now, from his lawyer's perspective, does this mean that the comment reflected the event, or the event was manufactured to echo the comment? And that'll be for the jury to decide. But my understanding is the court is also going to permit two other uncharged misconduct witnesses to testify, women who also had libidinal contacts with Trump. And the court will tell the jury, look, you cannot conclude that because he allegedly raped these other two, he therefore raped the first one, Ms. Carroll. But their evidence can be used to show his motive, his intent, his manner of operating, his modus operandi. It's a distinction that's largely without difference, I believe, in the jury's mind, but it's one of the ways that the court permits evidence of uncharged misconduct to be used in a criminal and or civil trial. But faced with that, the enormous antipathy to Trump, the number of times that his name has been in the news in an unflattering way, the demographics of the jury pool, the Access Hollywood remark, the two uncharged misconduct women, I believe there's a substantial likelihood that Trump is going to be found liable in the Carroll case, and I predict he will be.
Yeah, it just appears to me now that this is the 2024 election strategy coming from the Democrat Party in general. I think that this is going to be an election that is fought through the courts, but then we go to the ballot box next November. And we'll be talking much more about this and the other cases as they come up.
Fascinating article talking about the 2024 election. We didn't talk about this in our pre-show wrap-up, so I'm sorry to sandbag you here, Mike. But if you get a chance, take a look at Sunday's Washington Post on the op-ed page. George Will wrote a column about the no party candidate and his view. He took a look at polls and found a discernible lack of enthusiasm among registered Democrats and registered Republicans for a rerun of the 2020 campaign involving Biden and Trump, and a hunger for a third party candidate, the so-called no party, as Will put it. And he does a nice job of looking back at American presidential politics and talking about years in which third party candidates played a role, played a difference. Excuse me. But he pointed out that in order for a third party candidate to step into the void left by the two parties, that candidate has to have an agenda. And right now, we're a nation adrift. We have two candidates that members of most parties don't find to be all that appealing among a number of dimensions, but we don't have anybody else coming up with ideas to say, this is where I think we should go. This is a potentially magic moment in American politics. I've been talking for weeks about Walter Dean Burnham's book about critical elections as the mainstream of American politics, and how every 40 or 50 years ago, the parties realign because the old shoes that we're wearing don't fit. And we decide we need to walk in new shoes. candidates. I don't know who that third party candidate is. I don't know if there is a third party candidate that's capable of articulating a vision around which we can all gather. But I know there's a hunger for that vision. Vivek Ramaswamy is trying to talk it up on the Republican side. I thought Tucker Carlson did a good job in his 2-minute presentation last week of talking about it. There's a hunger, but I'm not sure who's going to feed us, as it were.
Sure. What about the lead here? Yeah.
Well, so come on, Sam. Tell us, Sam. I am Alito. He's got a teaser out there. I got a pretty good idea, he says, who the leaker of the case was in Dobbs versus Jackson Health. That person put a target on us. That person put a target on us. He, she, whatever it is, wanted us assassinated. He doesn't think he has enough information to share the person's identity. I don't know if you either put up or shut up is my view. And the Supreme Court as an institution has a limited number of suspects. It's not a criminal tribunal. You don't have to prove it beyond a reasonable doubt. But we would like to know. I mean, we're coming upon we're on the 1-year anniversary of the disclosure of what the opinion would be before it came out and all hell broke loose. If you've seen something, Sam, say something. It doesn't do good to play cutesy with the truth right now. Who said it? Who disclosed, and what's the Supreme Court going to do to keep it from happening again? And will it happen again? Because the two blockbuster decisions at the end of this term, decisions that, in my view, have the potential to inflame the country almost as much as the Dobbs decision did. Dobbs, as you will recall, overruled Roe versus Wade, declaring that there was no federal constitutional right to an abortion. We've got the two affirmative action cases that are getting ready to be decided and will be decided and announced most likely in late June at the end of the term. One involving University of North Carolina, the other involving Harvard. And there is reason to believe that the court will probably conclude 5-4 that affirmative action has outlived its usefulness in the United States, and that under the Equal Protection Clause, if we're going to treat people equally, if we aspire to treat people equally, we should start to treat people equally. Or, as Roberts put it in the Seattle School Board case years ago, if you want to end discrimination on basis of race, you can do so by stop discriminating on the basis of race. Right. That would fly in the face of our identitarian moment, and would undoubtedly outrage those on the left who think that identity is everything. And the racial profiteers hawking reparations would undoubtedly be offended. And perhaps they'd take to the streets again. Because, Mike, we're approaching the 3rd anniversary of George Floyd's death. And I suspect...
Thank George.
Yeah, I was waiting for you to say it. So, if you know Sam, I am. If you know something, say something.
Well, there's a couple of additional thoughts here. Number one, the Washington Post article does a decent job of having him articulate against the notion that perhaps it was somebody from within the conservative majority that would have done the leak, and he categorizes that as completely silly because they've been subject to death threats and their physical safety has become more vulnerable because of that. That in reality, it was quite the opposite, that it was a tactic that he now knows was deployed in an effort to perhaps persuade against the decision that had been reached. The other thing is simply this. We know that there's a lot of scrutiny on the Supreme Court right now for ethical reasons, right? We've got Justice Clarence Thomas. We've got the Chief Justice John Roberts in the news as well. And in this article, I'm just going to read here a quick quote. It says, quote, Alito declined to answer questions about Justice Clarence Thomas. The interviewers wrote, Thomas has been under fire after ProPublica reported that he accepted extravagant vacations, private jet travel, and gifts from his billionaire friend and Republican donor Harlan Crow, who also bought the justice's childhood home in which his mother continues to live. Thomas did not report the expenditures on his disclosure forms, which are supposed to provide transparency about potential ethical conflicts. Without commenting on Thomas, Alito said he believes that reports about alleged ethical violations by justices are attempts to damage the court's credibility now that conservatives are firmly in control. Quote, we are being hammered daily, and I think quite unfairly in a lot of instances, and practically nobody, is defending us, he said. And then those who are attacking us say, look how unpopular they are. Look how low their approval rating has sunk, Alito said. Well, yeah, what do you expect when you're day in and day out they're illegitimate. They're engaging in all sorts of unethical conduct. They're doing this. They're doing that. I think that captures the essence of what we've been talking about here recently, Norm, is that it is an interesting shift that when the court was perceived as having enough political firepower or partisan firepower, and I say perceived because it's supposed to be an apolitical body, but with the likes of the late Justice, her name is escaping me at the moment. How could it? I don't know how it could.
Ruth Bader Ginsburg, yeah.
Yes, but when there's some perception that the court is somewhat balanced or could lean left, there are no attacks at legitimacy or the credibility of the court. But we have seen now, in light of the Dobbs decision, with these affirmative action cases on the horizon, with what's going on out of Texas, we're now seeing quite a bit more lobs at the credibility of the justices, in particular, as if there's another way to perhaps loosen up some room and create vacancies on the court. And that's what Alito was talking about in this interview, is that, there was a thought that they were trying to get one or more of the conservative justices assassinated.
Yeah, well, it's chilling. And that it's funny you should use that word, the assassination word. I read a lot about American politics and the history of dissent in the United States, since I represent dissenting voices typically. And I've marveled at how peaceful our time is, how violent our rhetoric is. But, you look at the Weather Underground or the 60s and 70s and into the 80s and the number of groups that were involved in bombing campaigns. We don't have that now. You look at when I was a young child, becoming aware of the world, assassinations were common. John F. Kennedy was assassinated. Robert Kennedy was assassinated. Martin Luther King was assassinated. Malcolm X was assassinated. These days we have remarkably little political violence. Our speech is violent. And when we speak out, everybody has a hissy fit, but nothing really happens other than utterances. And I don't know what's become of this republic. We've become a republic of precious people, I think. Dissent, raucous voices, argument, even violence are as American as apple pie.
The protesters outside of the justices' homes is, we're not totally out of the woods on a lot of that stuff, and there's been plenty of pushback, albeit not to any legitimate effect. But with the Federal Department of Justice, doing what it's done here in the last couple of years, focusing pressure on parents showing up at school board meetings and stuff like that, but then allowing the continued, which is facially illegal, protest outside of justices' homes for weeks on end, it does lend itself to questions as to whether their safety and security is top of mind and whether there's a larger issue there. But I will also say, just generally speaking, just because we don't have bodies to point at, the likes of which you reference, Martin Luther King.
Bodies are buildings.
Yeah. That doesn't mean that violence has not translated into something else that could, that achieves the same means in terms of silence and unpersoning and stuff like that in 2023. So give some thought to that, Norm.
Yeah,
I think social media continues to be a very barbaric tool wielded against the unwitting. And to that end, we don't need bodies the same way that we used to.
It might be that we use social media against ourselves. I picked up an interesting book. The author, Thomas Chamorro Premizik, I don't know if I can pronounce it. It's called I, Human. AI, automation, and the quest to reclaim what makes us unique. His position is that artificial intelligence isn't a looming threat on the horizon that will someday wake up and say, I'm here, like Jack Nicholson does in The Shining. But rather, AI in the form of algorithms and social media is already ever present and around us. And we are augmented or manipulated or confined much more than we know, especially by our use of social media, where increasingly we fall into silos. We seek what pleases us rather than what extends our horizons. And the result is we become more fractured, more divided, and less capable of living a full and robust life. Take a look at it. It's a quick read. I, Human. I'm showing it up on the screen. AI, automation, and the quest to reclaim what makes us unique.
Will says that there was a joint letter issued by all 9 justices.
That's right. There was basically saying, look, separation of powers. We're not going to come up there and sing for our supper. We retain our judicial independence. We're capable of managing our own ethical ethical agenda, and stand down Pocahontas. Because if you look on social media, who has been all over this? Elizabeth Warren. I
That's
mean,
right.
you would
So
think that she
that's
had
right.
discovered gold, and she has. She's discovered partisan gold. And the claim is these people can't govern themselves. The court is out of control. It's gone off a right-wing ledge, and we need to pack the court with other justices. And so we've got a court packing a moment upon us. Hey, Luttrell, I'm glad that you're enjoying Life 3.0. Again, that is, you're a little over halfway through it. Finish it. What is amazing about that book to me is that it's one of the first books I read on AI a number of years ago, and I see echoes of that book in everything else I read, and I try to read broadly on the topic because I do believe that we're well into a new era. You can say it's the Anthropocene era, where we affect our climate and the world around us in ways we hitherto haven't. You can say it's the dawn of a new information age with computing power. Maybe it's both, but the world is filled with challenges, and we're here to try to help you meet them. And one of them is staying confined within our time lane.
That's right. That's right. So again, I want to just acknowledge we have a larger than usual following on Twitter this morning, or have enjoyed one. So thank you to all of you who joined via Twitter Live or Periscope, however you're finding us via that platform these days. But, first and foremost, our Rumble subscribers and our Rumble viewers, thank you as always for showing up. 7:45 every morning. Norm, I think we have agreed to move to 8 a.m. beginning next week. So not this week. We'll stay 7:45 this week. And pending the outcome of the J6 trial and the jury deliberations, we'll try to get back to an 8 a.m. start time. I think it's a little bit easier for people to join in depending on their time zones. Last but not least, you can obviously find us, as I've got scrolling at the bottom, on all major podcast platforms. So Apple Podcasts, Spotify, Google Play, Overcast, etc. Every morning stream is uploaded, the audio only version, to those platforms. So if you can't make it in the mornings, but you still want to get what we're talking about, you know where to find us.
You still want to get right with the world.
That's right. That's right. Norm, I'll let you go. I've got to get my week started as well. But it's been a pleasure. Very fun talking about the S2 stuff. I'm gonna dig a little more on that one.
And tomorrow we'll talk about why 95.5% of inmates in the Connecticut prisons are mentally ill.
That's right.
Were they there when they got there, or did it make them that way, or both?
Chicken or the egg there, but lots to dig in on that. All right, Norm, we will see you tomorrow. Thank you for everybody for watching. And if you have any questions, send us an email, pattispodcast@gmail.com. I know we have a few people that interact with us there week over week, but you can also reach us there. Anyway,
simple things like, why is there a world rather than not? We've got the answers.
See you, Norm.
See you.